Bienvenidos, damas y caballeros. How many Spanish speakers do we have here? Okay, excellent, excellent. Okay, so as Judge de Muniz said, I have done some teaching in Mexico. Soy mexicano, americano. And at home they call me Juan Mauricio Haroldson Suárez Rodríguez Gutiérrez Ballesteros de Lara, de Monterrey, Nuevo León. Okay? Now, I want to begin speaking with you about the direct examination, but I want to give it some context. The trial, I like to say, is como un baile. It's like a dance. And if you take one part of that dance out, you can practice that, but you don't have the complete dance unless you keep it all together. So already you have worked on opening statement, alegato de apertura, direct examination, interrogatorio, cross-examination will follow later, contra-interrogatorio, and then finally closing argument, alegato de clausura. The reason that I share both terms with you is because Mexico has gone through a reform of the criminal justice system, which was originally an inquisitorial system where trials were done by paper. But now trials are being done in real time. And so understanding that these are skill sets that apply in multiple countries, really. That there's value in understanding that there's vocabulary that matches those concepts. So let's examine the direct examination. Now, I hope you all have your pencils out and a piece of paper because I'm going to share some magic words with you. And I'm going to repeat this because sometimes it's a little fast. Who, what, why, where, when, and how. Who, what, why, where, when, and how. Who, what, why, where, when, and how. These are magic words that you can use to begin questions in the direct examination. Why? Because the direct questions in direct examination have to be open-ended. You can't suggest what the answer is. We're at Willamette University, right? I'm talking to you, right? See, I'm suggesting the answer. Today is Wednesday, right? That style of questioning is used in cross-examination, and if you use that style of questioning in direct examination, you risk someone objecting. Objeción. And the judge will say, fundamento, and you have to argue why it's not objectionable. Okay? So, ask open-ended questions. Now, what's the value of asking an open-ended question? The value is that the witness gets to tell their story. And when you're presenting your case, which is when you're using the direct examination, when you're presenting your case, you want your case to be strong. You want your witnesses to be credible. They get to tell the story. Your role in direct examination is much like the conductor of an orchestra. You conduct the orchestra, the audience sees your back, but they watch the musicians. You don't do the solo. So it's important when you ask the questions, you let the witness tell their story. Now, it's important to prepare your witnesses so that they understand what direction you're going to go. Otherwise, some witnesses may wind up talking for a long time and suddenly you can't control that. And that's an important part of preparation. Next, you also want to organize the story that the witness is going to say in chapters, so that you're not asking a little bit over here, coming back here. It's hard to keep track of that. You want to make it easy for the audience, the jury, or the judges to be able to follow the sequence of events or the themes, what we're going to talk about. For instance, you may have a witness. We'll say, take Socorro as an example in this case. What is Socorro's relationship to the plaintiff? What happened before they went to the coffee shop? What happened at the coffee shop? And what's happened since they were at the coffee shop? Each one of those is a different chapter. So while the rule is that you ask open-ended questions, who, what, why, where, who, what, why, where, when, and how, you also have an opportunity to introduce your chapters or to make transitions. Later we'll be talking about expert witnesses, but with regards to drawing a witness's attention, let's say you had a diagram, you could say, I would now like to turn your attention to the diagram that's marked Plaintiff's Exhibit 101. And then the witness and the record hears everything that's happening. And that's just an important side note because everything's recorded in the courtroom. And if it's not stated, it doesn't exist. So if you had a witness that you asked a question, the witness goes, what does that mean? When judges review the records on appeals, they're listening to everything that occurred in the case. And if it's not stated, it doesn't exist. Another example of that would be, I may say, how far away were you? How far away were you from the plaintiff when the coffee fell? And if Socorro says, oh, I was about this far away, that doesn't explain anything on the recorded record. So you would stand and address the court, that's a sign of respect, to say, Your Honor, we ask that the record reflect the witness has indicated a distance of approximately 1 foot. And if the defense does not object, then the court can rule on whether or not that will become part of the record. So always be mindful that if it's not stated, it doesn't exist. So let's go back to the form of the question that we're going to ask. Who, what, why, where, when, and how. Who were you with doesn't suggest who they were with. If I ask the plaintiff, were you with Socorro? That suggests it. Who were you with? What were you doing that day? Where were you going? How did you get there? What did you do? What time was it? What did you see? Who did you talk to? What did they say? All open-ended questions. So, I may ask Socorro. First, she sworn in, she states her name, spells her last name. And I may ask, do you know the plaintiff? And she may say, yes, I do. Could you please tell us how you know her? We work together, we've been friends. How long have you known her? I've known her for 3 years. How would you describe your relationship with the plaintiff? And let her tell the story. Now I'd like to take your attention to the day in question. And I would usually say the date, where the event happened, where the coffee was spilled. Do you recall that day? Yes, I do. Can you tell us where you were before you got to the coffee shop? Yes, and have her explain. When you got to the coffee shop, what did you do? We got in line to order a coffee. And can you explain what that line looks like? Now we're painting a picture. So it's a typical line. You go through, you place your order at the microphone, and then you go forward and you pick up your coffee at the window. Okay, and did you pick up the coffee at the window? Yes. Who handed it to you? Would you recognize that person if you saw them again? So I want to ask the open-ended questions, get the entire story. Now, why is this so important? Because typically, whether it's a civil case or a criminal case, the jury or certainly the jury, the judges, don't have all the information about the case till the evidence is presented. And so if we don't ask the questions, we're not going to be getting the story that we believe is important. And that leads us to 3 important points that has to do with evidence and testimony, because testimony is evidence in the case. When you present a witness, when we present a witness, we want to establish clearly who is this person. Second, why are they here? And third, why is that important? Another way to say that is identify the witness, have them tell their story, but do it in a way that demonstrates why it's relevant. Why is this witness relevant? Before you present any witness in your case in chief, using direct examination, you want to have answers to all those questions and to prepare your questions according to that model. Why is this witness relevant? What is it that you want to prove with this witness? And how can you best present that story? Now, sometimes it's tempting on direct examination to ask a witness, do you recall this day? Tell me what happened first. And then they tell you the fact. And then you say, and then what happened? And then what happened? And then what happened? And then what happened? And you sound like a typewriter that just keeps going back and forth. That can become annoying if you keep repeating the same words, or sometimes we get nervous and we say, or the witness answers and we say, okay. In Español decimos muletillas, okay? Those are like stuttering points. And so we want to be careful when we communicate that we're aware not only of the questions that we're asking, but how we are communicating with our body. What are we doing with our nervous energy? Because that can become a distraction. And instead of watching the orchestra, the jury begins to watch the conductor. So you don't want to create that distraction. So getting back to this chronological way of asking questions, that can be done. One could say, what was the first thing that happened? And then tell me what happened after that. But that captures a chronological reality. If we were just to say step by step, since I came in, I was here, I went here, I went here, I said these words, that's all chronological. But there are three realities to consider. There's the chronological reality, there's the cognitive reality, and then there is the emotional reality. So consider our plaintiff. Our plaintiff can probably tell you everything that happened step by step. And I could ask, and then what happened? And when she spilled that coffee and felt the coffee burn, what did you feel at that moment? And she might say, I felt like I was going to die. And what did you think? I had to save my life. So now we're not simply limiting ourselves to going through the chronology, the steps of what happened, but examining how that person felt at that time. And we bring the audience to life to be closer to that experience. When you finish your direct examination, you don't want to just sort of drift off into the sunset, but you want to ask a question that makes it clear that you have concluded. So remember, you organize your chapters, and on that last question, I may ask, Socorro, who's testified that she has stayed in contact with the plaintiff. And I may ask, since she was burned by the coffee, has she ever been the same? And she may say no. I may pause, politely stand, say, thank you. No further questions, Your Honor, to the court. And then the court will say, call your next, or go through cross-examination and perhaps allow me to ask a few more questions, but when that witness concludes, I need to be prepared to call my next witness because I'm presenting my case in chief. And with that, I want to be respectful of your time. I know that we are presenting a lot of information for you all at one time, but these are the fundamentals. And the best way to master these, the best way to reach that point where your verbal communication and nonverbal communication is coming together for a powerful presentation, an impactful presentation, is to practice. Final point I want to make is that when we feel shy or feel like our friends are watching us, sometimes we lock up and we don't take the risk to learn because we don't want to look foolish. I have many friends who have tried to learn new languages, And they have a hard time when they are such perfectionists that they don't want to make a mistake. Dive in. Open-ended questions. Let your witnesses tell the story. Thank you for your attention. Fabulous.